All right, Patrick McQueen in the house again. How the heck are you?
I'm great. I'm great. I think we kind of got like matching outfits on too. So that was totally unplanned and yep,
Okay.
greenish.
Coordinated, not. For those of you that don't know, Patrick McQueen is a local real estate attorney here in Arizona. He is the owner of Medalist Law, and he's just always so willing to hop on and kind of talk us through some of these laws that are happening and the impact to real estate agents or the real estate market itself. So, Patrick, again, thank you so much for your time. I cannot share with you how much I am grateful for it, and I know you're super busy. So, thank you.
Well, thanks for having me.
So we're going to talk HOA, new HOA laws. I can't wait to dive into these three topics. So let's start off with bad board members. I know that you have been in business for many years. You have seen your fair share of lawsuits. And to walk us through kind of like a bad board member scenario and then how this new law impacts that scenario.
Yeah, I'm glad you mentioned HOAs in general because we have about 10 or 12 new laws governing or dealing with HOAs. And so obviously we'll talk about a few of them today, but I do have a handout if anybody wants a list of all of the new ones that sort of are hitting us in 2025. We can get that to people
Right.
because I think that may be helpful. What we're seeing, I think, is a trend perhaps by the courts and by the legislature, which is our source of law, the legislature and the court interpretations here in the state, like, against HOAs. So it almost seems like we're pushing back and saying, okay, HOAs, you've had your fun. It's now time to let people do a little bit more with their properties and have a little more or less governance in terms of the HOAs. And one of the things that's come out is a new law 3318-13, ARS 3318-13, which is a situation or a new law that addresses these sort of bad or rogue board members. So let's say you have a board member who is making decisions without going through the proper channels, who is hiring contractors for the community because they're business associates or business buddies, who is targeting certain people for violations and isn't going after everybody for the same thing, who's maybe taking money and diverting funds. We see it all in Arizona. You would not believe the level of some things that we see HOA presidents doing, HOA board members doing. It's wild. It's somewhat like high school when everybody's sort of, we got this clique and that clique, and these cliques don't get along. So when you have a situation involving one of these bad board members, or maybe they're not even bad, maybe they're just dislikes, right? There is a process here in the state that allows you to remove them. And the process used to be very much litigated. And now we have this new statute that I mentioned that may or seems to be resulting in less litigation over this particular topic, which I think was the intended goal behind this.
So walk me through an example. We have an HOA, we have a bad board member, and I'm just a member of the community. Do I get to do something as the member of the community, or does it have to stem from another board member? Walk us through the steps.
Yeah, so I think it may be easiest if I go through how it used to work and then kind of show you how it now works. So let's say that you live in a community and you and some of your other neighbors, some of the other owners in the community, in the HOA, don't like John and Sally, who are board members who are acting, not on behalf of the company, but on behalf of themselves, etc. So in the olden days, a couple of years ago, you and your neighbors would have to get a petition signed, and that petition would have to be signed by a certain member or a certain percentage of owners within the community. If it was a community of over 1,000 people, it's 25% of the owners. I'm sorry, 10% of the owners. If it's less, then it needs to be signed by 25% of the owners. So they have to sign this special recall petition, right? And so you have to get the requisite amount of people depending on the size of the community. Well, let's say you got that petition and you want to have a special recall election to recall John and Sally because you've gotten enough support for this. You would then go and present this petition to the board. The board would then have an obligation to call a special meeting to determine or to have a vote on whether John and Sally are going to stick around. Okay. Well, what was happening and what has happened in the past is, let's say that the board members who received this petition, they really like John and Sally. They don't want to see John and Sally go. So guess what? They don't call that meeting, or they delay the meeting, or they give you issues about that meeting in the petition. They try to fight you on it. Well, guess what would happen in those situations? The aggrieved homeowners, you and your neighbors, would have to then turn and file a lawsuit against the board for not calling this special meeting and special election.
Yeah.
Well, now, upon receipt of that petition, the board must call that special meeting for an election within 30 days. Otherwise, the entire board is removed.
Oh.
They're all gone.
Wow.
So you can see what I'm saying about these new laws being pretty significant. And again, oftentimes when there was a valid petition signed by 25% or more, or 10% or more, depending on it, the board would just refuse to call the meeting. They wouldn't do anything. Now, if the meeting is not called, if that vote doesn't happen, and it doesn't happen in a timely manner, on the 31st day after that petition is provided, they're all gone. So I think that is going to result in less lawsuits against HOAs and by HOAs when it comes to this particular issue.
So what happens in that case? Technically, the board doesn't act, and then after 30 days, they're supposed to be removed. But like, who physically does that? Who isn't there going to be some action or some need to get enforcement legal involved? I mean, why is the board like, yeah, no, I'm not leaving? Let's just say that.
Yeah, no, that's a good question. At that point, you probably would need to get legal counsel involved. But no, that's a fair question. There's a little, not a loophole. There's just some stuff that's missing. So what are the next steps?
Yeah.
I've actually seen, when this thing first came out, the board was presented with this. They didn't know about this new law. And so on day 31, the homeowners were super happy. They didn't do anything. They didn't call this meeting. What do we do now? What we did in that situation is we sent a letter to the board and said, you guys are all gone. And they recognized it. They had legal counsel look at this and confirm, hey, we're out of here. And so a new election had to happen. And so it can create a little bit of a mess. Yeah. If the board doesn't leave, then you do also have to, let's say that in that situation, it didn't work out so smoothly. In those situations, you would have to seek some sort of restraining order or injunctive relief to have a court order saying, hey, you guys are all gone now because you didn't do this, and here are the next steps that need to take. But normally the next steps are, we're going to have a new election, and we may have a gap in coverage on who the board members are for a little bit of time.
Yeah. Such great information. Let's move into transfer fees. There's been some changes with HOA laws and transfer fees. Fill us in.
Yeah, this one is, I kind of didn't think much of it. And then a lot of people were like, oh no, this is a big deal. And they told me that they think it's a big deal. And what it is, it's ARS 33-442. And it basically prohibits an HOA from charging a transfer fee if there is a conveyance between family members or related entities. Okay. So let's say that you're doing something for estate planning purposes and you convey the property to someone that's related to you or a related entity. In those situations in the past, right, in the olden days, the HOA had the ability to issue a transfer fee and required you to pay a few $100 every time you did that. And so that sort of got people thinking, I don't want to spend that kind of money just to do this. I'm not going to do it. And so now, by statute, they can no longer do that. They can charge an administrative fee, but they can't charge some of these exorbitant transfer fees. And to me, it's good. It's good policy. It's good public policy, because we want people to feel free to transfer to related entities, particularly for estate planning purposes. It's like the issue with the due on sale clause in a mortgage loan document and in a deed of trust or note. It's okay if you transfer your property to a related trust or a family member for estate planning purposes. We have the Garn-St. Germain Act and some other things that say you can do that, because we want to promote these types of transfers. So we're not going to ding you on the due on sale clause. We're not going to call your loan due, kind of a thing. Same kind of concept here. We want to promote these types of transactions. And so we're going to make it so HOAs can't ding people on them and charge them just because they wanted to do an intra-family transfer. So again, another law that pushes back on all of this authority that HOAs had and the ability to collect all sorts of fees, et cetera. So we're slowly pushing back a little bit on the power that HOAs have.
If I'm a homeowner in a community that has an HOA and I am transferring my property into a trust, it would apply under this, I'm guessing, right? Because it's my trust, or I'm a beneficiary, or somebody in my family is. And the HOA says, nope, there's a transfer fee. Now what do I do? Is that homeowner? I go to your website. You're going to have some type of communication on there that I can download, and I would send it back to the HOA and say, hey, HOA, maybe you missed this, but here's the new law. Please, proceed. I'm transferring it, whatever. And please know I do not intend to be charged. Is that kind of a fair process? Is there anything else we should be doing?
Yeah, I think they should send them this video that we're doing right now and say, Patrick and Kelly said, no, you can't do this. But yeah, I mean, I think that most are recognizing this as, the law now. I haven't seen anybody with a real issue here. I think it's good. But if they do run into it, then, they're going to want to say, take a look at ARS 33442. You can't ask me for this. You can't bury it in there and charge me for some other random charge when truly it's a transfer fee charge. It's a pushback for sure. And they're saying, look, this is stuff we want to protect. We want to protect these types of transfers.
So you said something just now and made me think. I mean, couldn't they just call it a different type of fee? And therefore then, it's not applicable under a transfer fee. It's a whatever, a willy-nilly fee. I mean, and then is that okay?
I would hope they'd use something other than willy-nilly. But yeah, I think ultimately, if there's any charge, I think, again, I think there's going to be some HOAs and perhaps some property management companies that try to get cute with the language. But ultimately, if you are charging me an amount based on the fact that all I want to do is transfer this to a family member or a trust, if there's any charge, you can call it the willy-nilly transfer fee, whatever you want to call it, can't do it. And so I do think there will be HOAs and condo associations out there that are going to push the limits and see what they can do. But ultimately, they really can't get away with it.
Has there been any change on transfer fees when it comes to purchasing a home? Are there any caps on transfer fees to your knowledge? Obviously, we see a lot of that in the mortgage business. We'll get the purchase contract, we'll get, the HOA addendum and all the details of the fees that are associated with the purchase of the property. Anything we need to know on that front?
We don't see a ton of that or issues that arise when it comes to that. So we're not reviewing settlement statements that much and documenting and making sure that those fees are in line with what the HOA is allowed to do. So we don't see a ton of that. We don't get into those details too often.
Okay, that's good. Well, Patrick, thank you so much for your insight. One more thing. I know this is going to get a little crazy. So are you ready?
I'm ready.
I want to know about this unlawful restrictive covenants. What the heck does that mean? And what do I need to know?
Yeah, I'm going to see if I have this written down as to the statute for this one, because this one is actually pretty interesting. And it brings me back to when I was just a kid, fresh out of law school. What we would see, and I don't have the statutory reference, but I can shoot that over to you. I thought I had some notes on it. But so what we would see in documents here in the state of Arizona, they were everywhere, unfortunately, are some really bad documents. And what I'm getting at are situations in which maybe in a deed or in a deed restriction or some sort of restrictive covenant, you would see language that says, hey, I'm selling you this property, but if you ever resell the property to someone of this descent or someone from this origin or from someone who is this color, guess what? I get the property back. Or they would say all of these sort of other horrific types of things. These are in our documents. These are recorded. This is recorded history in this state and in many other states. And so when I first got out of law school, I'd heard of the concept, but I didn't really know what it meant until I'm reviewing somebody's title report and seeing, oh, whoa, this is offensive. This is bad. This is, whatever. And, I would just continue reading on. And what we would see then is in language in your title policy, there's a reference to the Civil Rights Act of 1968 that says these restrictive covenants are unenforceable. So there was something in a title report. If anybody's ever looked at a title report or title policy, there's a reference to that. It's quite interesting, but everybody just glazes over it. So in 1968, there was the Civil Rights Act, and it basically said, look, this stuff is unenforceable. So this stuff from the 20s, 30s, and 40s that is in our recorded documents is unenforceable. But we're not removing it. We're not doing anything to sort of have it invalidated. It's there. It's part of history, but we're not doing anything. Well, now under Arizona law, if there is an unlawful restrictive covenant, a homeowner within a condo association or an HOA who doesn't like that language, who wants to see that removed, can actually record a document to have it sort of invalidated. So everybody knows when you buy my property from me, it doesn't apply because the title company says it doesn't apply, because the 1968 Civil Rights Act says it doesn't apply, but it is removed. It is removed. It's still not truly removed. It's basically amended to say, I don't agree with this. It's gone. And so now HOAs can do it on their own, or homeowners within HOAs can do it on their own. So if anybody wants a form for that, let me know. We have a form that you can do. Now, the concern I have with this statute isn't its goal, stated purpose, etc. It's someone who takes my form and tries to remove something else that the HOA can do or can enforce. Well, this is an unlawful restrictive covenant. No, that's not the purpose of the statute. The purpose of the statute was to get rid of the offensive language that nobody likes, that nobody wants. It's not to get rid of the fees as they apply to you or the architectural review committee or whatever. Can't do that. It has to be one of these sort of prohibited types of language in there. So again, I have a form. Once I give you the form, I'm not giving you any legal advice.
You're on your own.
You're on your own.
All right. Well, Patrick, is there anything else out there with regard to HOA laws, any juicy stories, any litigation that maybe you just wrapped up that you can speak about that we should know?
The parking one, I think we mentioned this on a prior video. That one is the most divisive HOA law that I've seen in a long time. And I had really no idea because I don't really have the need for off driveway or parking. I park in my garage. I park in my driveway. I don't have a bunch of guests coming over. I don't have a bunch of kids lining up and parking in front of me, but a lot of people do.
Yeah.
And so this parking new law has a lot of people up in arms. So remember, under the new parking statute, HOAs are going to have their ability to govern parking on public roadways. They're going to have those taken away from them unless there is an affirmative vote, a yes vote of 51% of the members in the association say, yes, we want you to continue governing parking. And so that new statute is getting a lot of people who are not happy one way or the other. So they say, HOAs, you still need to govern. We can't have this in front of our house. Others are saying, cool, we don't even need to have a vote. Let's start parking where we want. And so there's a lot of misinterpretations. There's a lot of frustration over this one. I had no idea that this was such a big deal. But now that I've brought it to light or have seen it brought to light, a lot of people have some strong opinions on it.
So if you live in a community that has an HOA and you're a resident that doesn't want people parking on the street, then you might want to contact your HOA and talk with them and have they reaffirmed this particular parking policy. Is that the right verbiage? So then you would have awareness. So then if somebody is parking on the street and they did reaffirm it, then I could report them to the HOA and the HOA would do something about it. Is that kind of the course of action?
It's essentially, but there has to be a community-wide vote to reaffirm it. Mm-hmm. So if your HOA currently governs parking on public roadways, so if the current policy of the HOA is that they can dictate, parking and hours of parking, etc., and you want that to continue, you need to tell your HOA that we need to have this vote. When is the vote? And you need to vote yes for that. If you don't care one way or the other, or if you don't care, or if you want there to be freer access to parking in the HOA not to be able, then you need to tell the HOA we need to have this vote and you need to vote no. So there has to be a vote by the HOA by the end of June of 2025. If the vote doesn't happen, it is deemed to fail, right? It automatically fails. And so if there is no vote or the vote is no, then the HOAs can no longer govern. And so what we've seen are some HOAs that say, we're not even going to have a vote. Like, it's our prerogative right now. We're not even going to have a vote. And so some people in those communities have had to file lawsuits saying, no, the statute says you have to have a vote. You can't make the determination now. It has to be a vote of the entire community.
That's interesting, because if you bought in a community knowing that that was the regulation and you support not having people park on the street, if you will, then I can see how that could be frustrating or, potentially just ruin the community in your eyes. I think everybody's got a different opinion on it, but yeah, I can see how it could be so divisive.
It is. One of the other things that we're dealing with in a couple of communities, actually, they're higher end communities in the state and or in Maricopa County, anyways, and it's criminal activity. So, what is the HOA's obligation if the HOA knows that there are crimes being committed in certain neighborhoods to inform people? Now, obviously, HOAs, they're not there to safeguard you. They're not there to protect you. They can't. They don't have that sort of police power. That and the liability would be pretty wild if they were out there doing something like that. But what is the HOA's obligation to inform you or inform its residents that there's crime, there's ongoing crime happening, there's burglaries happening in the community? And so what we've seen, what we had to do recently was, because an HOA wasn't reporting this, and we had a bunch of people who were getting burglarized and they didn't want to continue that happen. And a lot of people didn't know about it and they were just unaware. And so we went to the HOA and the HOA goes, we don't have an obligation to do anything. Maybe we know about it, maybe we don't, but we don't have an obligation. And so our argument was, once you become aware that this is happening in the community, you're negligent if you don't give this information out. You don't have to go and police it, but you just have to tell people about it, or you should tell people about it. So that's one we have pending right now. I don't know how that's going to turn out, but I thought that was a pretty interesting one, that obviously we think that they should report this or tell others in the community so they can protect themselves. But they're taking a different approach that says it's not in the documents that we have to do that.
Why do you think they wouldn't? I mean, what would be the downside, whether it's in the document or not? Why would they not just send out a quick email just saying, hey guys, here's a trend, here's what's happening? And
I think maybe they're concerned that they're wrong and then they end up defaming somebody. I think that they think perhaps that maybe our obligation goes further than this, and we don't want to start this trend in motion where if we tell you about this, then we have to protect the pools and protect the common areas and those types of things. So I think their concern is probably this sort of opening of a Pandora's box where we have further obligations to safeguard. I don't know. I mean, we're waiting to see what the real contention is. I think there's got to be something more than, well, it's not in the documents.
Yeah. Seems like
yeah. Yep. Exactly.
I mean, they could just follow, suit like attorneys and just have that big long disclaimer that just says this is not intended to be legal advice, blah, 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 right? And they could just do the same thing.
Exactly.
Be like, hey, this is just informational purposes, educational purposes only, and I would guess I would protect them. But well, Patrick, if people have questions about any of this, where would they find you? Where would they find the information on the new HOA laws?
So we do a lot on Instagram at Medalist Legal. We post a lot of just quick little videos about stuff like that. You can go to our website, which is medalistlegal.com. You can give us a call, 602-767-0050. Those are really the easiest ways. If you want any of the charts, etc., I can either forward them to you or I can give you my email address, which is pmcqueen, PMACQUEEN at Medalist Legal. So those are the ways you can get additional information about some of the things we talked about.
Awesome. And definitely follow Patrick on social. He provides great content outside of what he does with me. And so it's good stuff. I liked your Valentine's Day poem, by the way. Yes, one person read it. No, I'm just teasing. I'm sure many. All right. Be sure to share this. And if you're in Arizona and you have friends or family that live in HOAs, please be sure to share this. This is good stuff, you guys. And this is the stuff that we miss many times as homeowners. So, Patrick, thank you so much for joining me today and your insights.
Well, thank you. Thanks for having me.
Bye-bye. Right.